Hello, everybody. I guess everybody can hear us now. We're going to start the event shortly. Thank you, everybody, for joining.
Thanks, Antonio. Welcome, everybody. I can't see who's on screen, so I'm assuming there are a number of people, Antonio tells me. And I've got a number of people here, so welcome to the people at BCS HQ. So my name is Sam Silva. For those who don't know me, I am quite involved with the BCS. I'm on the trustee board and council member, and I'm the chair of the Law SG. That's all in my spare time as a day job, and to pay the fees of my kids at private school, I have to work. So I'm a partner at a law firm, CMS. I and my associate, who's Lili, who's a senior associate, who will be doing this presentation on contractual issues and consulting engagement. So in terms of what we're going to talk about, we talk about liability, talk about indemnities, intellectual property, scope of work, acceptance testing, change of control, termination, some of the protections we can build into the consultant, and then Lili will talk about that thorny topic of data protection. Even though it's one bullet point, it is quite a complex one, so we didn't try to divide it into the various things she will cover. So,
sorry, confidentiality you're skipping, are you deliberately?
That was confidential, so I didn't want to disclose that. But obviously, if we've got time at the end, we can talk about that. Just sort of set the scene here. So this session is aimed at those consultants employed in sort of SMEs and large consulting firms. Although a number of these things will be relevant for, the one-man sort of companies, but it's mainly focused on those areas. So in terms of terminology, I mean, we talk about consulting agreement, terms of engagement letters, T's and C's. They're all pretty much the same thing. Yeah, they're basically the arrangement that you have with your customer. There's no sort of, no scientific or legal definition of those things which make something different to the other. They're all sort of generic terms. Often there's a concept of a consulting proposal. Now that's really the document that you as a consultancy provides to the customer, basically setting out sort of what your proposal is in terms of your services. And that's often not drafted in legal speak, doesn't necessarily have to be. It's prior to the contract, effectively, for you to get the engagement. So that is what I'm going to cover for the purposes of recording. We're setting the scene, as is mentioned, those terms, consulting agreement, terms of engagement letter, all mean the same thing. There's no sort of scientific defined or legal sort of meaning to those things. So the question often our clients ask is, whose form of contract should we use? Should we use our own form of contract presented to the customer, or should we use the customer's contract? I think the preference obviously would be to use your form of contract, but clearly it depends on your negotiating leverage. So if your customer is a big bank, or if it's a large life sciences company, your ability to sort of impose your own contract is very limited. But where you can, you should use your own formal contracts. Obviously, if you use the customer's contract, it'll be pretty one-sided, protecting their interests. Use of templates. Now, I know you can get a lot of these contracts off the internet. Probably could ask ChatGPT, although I did ask ChatGPT to draft a contract and says we don't provide legal advice or draft contracts. So it won't give you a contract, but you can obviously go to a number of different sort of, service providers and get templates. You could probably, potentially there are other sort of templates which are already being done, and you may be tempted to, cut and paste that. I would warn you, obviously there's a copyright infringement issue. Some people think just because it's in the internet, it's basically public domain. It's not. Someone will own the copyright. So I would, have some concern about, you copying that. But, the other thing is, if you're using these templates, sometimes these templates aren't drafted to cover sort of specific nuances. So again, you should make sure that it actually addresses the issues, rather than just assuming that some service provider who's providing a consulting template is actually, meets all the requirements it needs to. What you need to be, acknowledges that agreements don't need to be in writing or in a specified format. So you could have an exchange of emails and you will have an agreement to form. You could actually, have a telephone conversation, for example. You could be talking to a customer. Yeah, I'll do these services X, A, B, and C. If you pay me, Z, customer says yes, that is a contract, it's an oral contract. So it doesn't have to be writing, it doesn't have to be signed. There will be a contract if there is an exchange of promises, i.e. you say that you will do something, they say they will pay, that will be a contract. Clearly, having a written contract is much better because if there's a dispute, you can actually point to words on a page and it's more certainty. Even if you do have a written contract, what you need to make sure is there's no inadvertent variations to that contract. So, you may have a contract and you may sort of have another exchange of emails or a conversation, and that could actually alter the written contract. So you need to be careful for that. You also need to think about pre-contractual liability, i.e., if you have a contract, it's always good to exclude anything which is done before the contract. So what you're effectively saying is the contract, the terms of this contract is basically what governs the relationship. There's nothing which has been said before or done before which you can sort of bring into it and effectively make a claim against. So basically it's the four square principle, i.e. everything's set out in the contract.
Is that the same as an entire agreement clause?
It is, yes. So liability. So what is the position? I'm going to ask anyone, people in the audience, in the room or online, what is the position if liability is not mentioned? Anyone want to answer?
Oh, then it's unlimited.
Yes. You have unlimited liability. So just because you haven't mentioned liability, you have unlimited liability. So you obviously want to avoid that. So that's why you put in a limitation on liability clause and exclusion on liability clause. They're related concepts, but they're different. So a limitation on liability actually limits your liability to a specified amount, whereas an exclusion on liability actually excludes liability for certain things. For example, loss of revenue or loss of business or something. So, obviously as an IT consultant, you don't want to have liability where you're doing IT consultancy and you do something wrong and then they lose a whole lot of business and they come to make a claim against. So you want to exclude those kind of categories of loss. There's some categories of loss which can't be excluded by law. So death or personal injury caused by negligence, that can't be excluded. Misrepresentation can also be excluded. So you can't tell forklifts, unfortunately. Well, you can, but you'll still be liable for that. Then there's certain things which are implied by law, which can't be excluded. So there's the warranties as to title and quiet possession. So that, in terms of goods, that would be relevant where you're actually delivering some kind of deliverables, whether it's a software product or a report, that will be categorized as a good. So you can't exclude those implied warranties as to title. Or in terms of the quality of the goods. Setting a liability cap. So that's an interesting one. How do you set the liability? I mean, ideally, you would probably want to say you've got no liability, but that's not going to be practical. The usual position is you basically cap your liability to the amounts that you actually get paid from the customer, not the actual amounts that they will pay you, because they may not. They may not pay you. It's actually the amounts that you receive.
I think it's
We've got a few people who've come in. Welcome.
Thank you.
David.
Yeah.
I thought there's some case law about that, and whether you have to limit the liability to 125% of fee.
No, it's free from contract. You can
choose 100% and the court is fine.
Yeah. You could choose, presumably, you could choose, 50%.
Okay.
Yeah. I mean, obviously, if you choose something really unreasonable like 0, then after comes into play, it's unfair and unreasonable. But
and they probably wouldn't sign it.
Sorry,
and the other party probably wouldn't sign it.
Well, they may if they didn't read it. So yeah, you need to be clear what your liability cap is. You also need to look at where your customer is trying to, make sort of exceptions to the liability cap. So sometimes they say liability caps is 100% of your charge is fine, but there's other categories, and Lili will talk about it in relation to data protection. They may want a higher liability cap for IP infringement. Sometimes they want unlimited liability. So you need to think about, it's not a blanket sort of limit of 100% of your charges or 150%. There will be exceptions that you will have to negotiate. Indirect and consequential losses. So these are losses which are one step removed. So contract law 101, direct losses are losses which directly flow from the breach. So let's say, for argument's sake, you're doing IT consultancy, you produced a piece of software, software doesn't work, but what the direct loss would be effectively the customer suing you for the amount they've paid for that software development. That's a direct loss.
So I'm just going to read one of the comments. We have Srinath mentioning that there might be outwards concerns when the project goes beyond the agreed timelines. I think you have already made a point.
Sorry?
There might be outward concerns when projects go beyond the agreed timelines. So we have timelines.
Yeah.
When the project that timelines.
Yeah.
So probably with the liability you want to include, or maybe you can include, maybe I can ask Srinath to just speak himself.
Okay.
Hi, Srinath, can you mute yourself and ask the question? And now I don't know how we can hear it. I think we hear the question from there.
Hi, thank you very much.
Hello.
I was referring to the question you asked about the liability in the start. So that's why I mentioned about the project. So sometimes project might not go according to the plan, right? So there might be some concerns related to the money and the timeline which we agreed upon. So that could be one of the liabilities which we need to be fully understand about it.
Yeah, so that would be a breach of contract. So if you agree a particular timetable to do something and you don't deliver in that particular timetable, that will be a breach of contract, and that's why it's important to have a limitation on liability clause to limit your liability in that scenario. Yeah?
That's right.
Okay.
And do you want to also say that time is not of the essence in this contract?
You don't necessarily need to say that. I mean, most customers would, clients would sort of refuse to accept that. I mean, ideally, if you could put that in, put that in. But, what you don't want is time is of essence. But I think getting time is not of essence is going to be very difficult for you to get in a contract.
Really?
Yeah. Unless you're dealing with someone who's not astute customer. Yeah. But most astute customers won't accept
If the contract is silent on that, then
it's just normal principles. Yeah.
It just comes up to reasonableness, does it?
Well, no, it comes back to the actual express obligations in the contract. Talked about direct losses. So indirect and consequential losses, one step removed. So in that example, whereas the direct cost was the cost that they paid you for the software that you developed, the indirect cost would be, for example, them saying, well, if you had developed this software, we would have got all this extra business. You didn't develop the software according to specification. We haven't got this extra business, so that's an indirect loss. And obviously, you want to try to exclude indirect and consequential losses. The devil is in the detail. I'll explain there. So there's two examples there. So what is the difference in the consequence? Anyone in the room or anyone in the online?
I don't have anyone online yet.
Not at all.
No, we have people.
Isn't the difference one word?
It is. But what does that mean?
Okay, so if they can sue for direct loss of profit under the second one, but they can't in the first one. Because in the second one, the loss of profit can they can only take action if it's a consequential loss. Oh, sorry, the covers excluded consequential loss, including loss of profit, but as not excluded that as a direct loss in example 2.
Yeah, so which one is better for the consultant?
Example 1. Because in example 1, we've excluded all loss of profit.
Yeah.
Whereas in example 2, we've only excluded loss of profit if it was consequential loss.
Yeah. So in example 2, because of that word including, you only exclude indirect loss of profit or indirect loss of revenue or indirect loss of business. So you would still be liable for direct loss of profit or direct loss of revenue. Whereas in example 1, basically, because there's no word including, you would exclude indirect losses and consequential losses and loss of profit. So that loss of profit would both be direct and indirect. So that one word including has fairly significant consequences. So obviously, I think, your ideal position would be this, but most customers will be astute to that. And I think the position you will end up is example 1. But obviously, I think sometimes customers who use maybe a US organization and they've got a US template contract and then it's been anglicized. Sometimes when it's been anglicized, they don't actually pick up this point. So lots of US contracts, this is based on English case law, would have the example 2. So obviously if it's example 2, you wouldn't sort of raise any objections to it because that's favorable to you. So Unfair Contracts Terms Act. So this is a piece of legislation which effectively says that if there's parties of equal bargaining strength and if a contract is negotiated on standard terms. Now, standard terms doesn't mean the contract can't be negotiated. So there's been case law which says even if a contract's being negotiated, it may still be standard. So what ACTA says is if there is a clause which is unreasonable, it will be held to be unenforceable, so it wouldn't apply. So in the case of a limitation on liability clause, let's say you say you're not liable for anything. Yeah, basically you can do anything. You have zero liability. In most cases, ACTA would apply, and it would say the customer would say, probably go to court to sue you if they had damages, and they would say ACTA applies, this is unreasonable. And if a court held that it was unreasonable, that whole limitation liability clause will be struck out, and effectively you'd have unlimited liability. So you're actually in a worse off position. So it's always better to have a reasonable limitation or exclusion liability clause in your contract. So indemnities. So often people don't really understand indemnities. So let's take the situation where you don't have an indemnity. Yeah. So you as a consultant, provide a service or a product. You don't provide it properly. What happens? So if there was an indemnity, the customer would have to sue you for breach of contract. So it'll have to prove its loss. The loss it suffered, it has to take steps to mitigate its loss. It may not be able to recover all its sort of incidental costs, ancillary costs, for example, legal expenses and so forth. And importantly, it has to show that the actual loss has been caused as a result of the breach, i.e. because this was done, or not done, that's actually caused the breach. So it's quite a high threshold to claim breach of contract, yeah? But that's why customers, your clients, will often put an indemnity in. Because if they put an indemnity in, under an indemnity, it is much easier for them to get money from you. So it's effectively like a promise that you will have to reimburse them for any expenses. So basically that also removes their obligation to mitigate their loss. And then they don't necessarily have to prove that the actual breach caused the loss. All they have to prove is that the actual triggering event actually happened. So indemnities is actually, quite an onerous obligation. So you want to try to avoid providing any indemnities.
And is it reasonable to do so?
Yeah, in most cases, yeah. I mean, again, it depends on negotiating leverage, yeah. If you're negotiating with big, large financial or life sciences company or a big one, they will try to put indemnities. But then obviously you want to try to limit your liability under the indemnities as well. So you don't want an uncapped indemnity. So in terms of IP, there are three types of IP, yeah, really. There's copyright, which actually is about the written word and so forth. So programming code, any documents you produce, there's copyright. That doesn't need to be registered. That just arises as a matter of, when it's created. Then there's patents, which obviously you need to register. That's a bit more. That's more of a process. And then there's database rights. So effectively, these are rights which arise because there's a considerable amount of effort that goes into compiling a database, and that's an IP right in itself. Now, know-how is quite hard to protect because that doesn't really fall into copyright, patents, or databases. So this is where I do have to look up confidential. I didn't realize that's where confidentiality or NDAs or confidentiality provisions come in. That protects the know-how. This is basically any processes or anything that you bring into the table. It's hard to get it protected by other forms of IP, and that's why confidentiality is important. Now, in terms of what your consulting engagement needs to answer, you need to make sure that the clauses answer these questions. What IP is owned by the consultant? What IP is owned by the client? What IP is retained by the client after the consultant delivered the service? What license terms apply to the IP to the consultant who transfers it to the client? And what IP is returned or destroyed on project completion. So if your engagement letter doesn't answer those questions, you've probably got a bit of work to do. So those are the key questions that, you need to look at your engagement letter and say, does it answer those questions? So in terms of scope of work and services, this is really, what you're actually providing to the client. So the problem areas is basically cut and paste of the consulting proposal. So I mentioned the consulting proposal, this is basically your sales bid, it's all in sales speak. We'll do everything, we're the best, blah, blah, blah. I'm sure. So I've often seen, and where problems happen, where the consultants actually cut and paste that and put that as a schedule to the legal document. That becomes contractually binding. So that is a problem. If you are going to put the consulting proposal, it needs to be reviewed from a perspective of these are legal obligations to be part of the contract. So, you can't, you need to try to avoid sales speak and sort of promising the world. Open-ended obligations. So, these are obligations where you effectively say, we will reduce your costs, but not actually say what costs are. It needs to be precise in terms of what you're actually performing. Sometimes the scope of service is not drafted to ensure contractual enforceability. And why that's a problem from a client perspective is you get into a debate. The client thinks you promised this, you say, well, that wasn't the intention. So it needs to be quite precise what you're actually doing. And that relates to the next point, lack of precision and specificity. It needs to be really detailed in terms of what are you delivering, what is the client paying for in terms of your services. And, you should try to avoid, outcomes because, obviously, from a client perspective, that's great that they want outcomes, but, sometimes the outcomes may not be within your control. So you want to try to be quite prescriptive and say, we will do this, or, we will deliver this particular thing, rather than saying, we will make sure, we will sort of, increase your profitability. I'm sure you don't do that, but that's just an example of that kind of outcomes. So in terms, saying state the outcomes, which are specific and measurable. A person mentioned time frames. So if you're putting time frames, need to make sure you include milestones there. What are the resources to be allocated? customer requirements. So often these consulting engagements, you need the customer to do stuff. So, if they don't do stuff like provide input or review your documentations, you're going to be, basically you won't meet the project milestone. So you need to specify their obligations and their, what they need to do as customer requirements. Then there's dependency. So your services may be dependent on third parties. So if the third party doesn't do that, you won't be able to deliver. So again, those kind of dependencies need to be specified and set out. And then they also need to set out exclusions. So if you're not doing certain things or certain things that are outside your scope of services, you need to exclude them because otherwise they'll be implied to be included. So yeah. So acceptance testing. So this is really the process that the customer uses to ensure that they get value for money, to ensure that, when they're paying for something, they actually get an outcome. Often there's sort of stage testing, for complex consulting engagements. There's sort of developmental testing, which is done by the programmers. And there's sort of use acceptance testing when the users do. And there's this volume and stress testing when the software gets deployed live. For simple sort of engagements, you won't have those tiered acceptance testing, but for the more complex one, you will. I mean, from a consultant perspective, you want to try to avoid acceptance testing. That would be the ideal position, but most astute customers will want to have some kind of form of acceptance testing. You've got a concept of acceptance certificate, and why that's important is it often triggers a payment obligation. So you want to make sure that if it does, then it's, you know what you need to do in order to issue that acceptance certificate. Otherwise, you won't get paid. There's also, what happens if there's a disagreement on the results of acceptance testing. So you may say, yes, that passes acceptance testing, and the customer says, no, it doesn't pass acceptance testing. So what you want to make sure is if there's some kind of dispute, there is potential referral to an expert. So a third party comes in and then they can make a next call. Good evening. You also want to avoid this thing called continuous loop, or I like to call this the groundhog concept. Anyone watch Groundhog Day? Can you remember it? Yeah, we're all showing our age. I'm sure Lili hasn't ever seen that. You haven't seen it, have you? No. So the continuous loop is effectively you're in the situation where you deliver a product, you say it's accepted. You do acceptance testing, it hasn't passed the acceptance testing, and then you say, okay, we'll do some modification, you do some modification, ready for acceptance testing, do the acceptance testing, it's not, and it goes backwards and forwards. So at some stage, I think both parties will get probably frustrated. Customers will often want to put a termination right there. You want to try to avoid that as much as possible, and sometimes they will give you a number of chances to get it right. Again, the greater number of chances, the better to use. So something to actually watch in terms of acceptance testing provision, in terms of their right to terminate, and how many times you've got to basically get it right. The other thing is you want to sort of make sure that that you're aware that there could be a trigger where they say if it fails acceptance testing, then basically you've got to refund all the amounts that we paid you. So again, obviously from a customer consultant perspective, that's not a very good position. So just those things you should watch out for. Now, deemed acceptance, that's a good concept for you as a consultant. We've got a few people laughing here. So this is effectively where acceptance doesn't actually happen, but is deemed to have happened. So often, a good position to say is, if you don't tell us within 3 days or X number of days that, you've got issues with what we've delivered, then it's deemed to be accepted. So, if you can build in deemed acceptance, that's great. Again, astute sort of clients may sort of be wary of that, but it is a useful sort of protection or mechanism to have. So pricing for change control. So change will happen. Yeah. So you need to make sure that, in terms of the change control mechanism, one other important thing, pricing, for certain changes, you may pre-agree pricing, yeah? So effectively change control is an agreement to agree, which is not enforceable. So you can't force another party to agree to a change. So that's why you need to build in certain transparency. So, pricing, there may be certain changes, where you can sort of build a sort of pricing. It could be like a menu item. Say, for example, we need to bring an additional person in, or if we do this kind of development, the price will be this. Often, customers will say, as a result of change control, if you're going down the change control process, you need to give us an impact assessment. Now, you might want to consider, well, fine, but you might want to consider having the ability to charge for that, because often clients may ask you for a lot of changes, and then you go through a whole lot, or the consultants nodding their head, they ask you for a whole lot of changes, you go through a whole lot of work and stuff, and they go, oh no, we're not going to do that, So you may want the ability to charge and say, yeah, fine, we will provide this sort of impact assessment or a proposal, but we can charge for it. It's like a small piece of consulting. Whether that's acceptable or not depends on the negotiating leverage. Flexibility. So again, flexibility, I think, is important for both parties. So there may be certain changes which are fairly sort of minuscule or not material, where you don't want to go through this whole change control process. So you may want to say, these categories of changes, we won't go through the change control process, but this is actually what will happen. Often customers will say, well, there are specific changes that don't attract charges. So they may say minor technological changes in law, or continuous improvement. Now, obviously, the bigger the list here, the worse it is for you as a consultant. So you want to try to make that list nothing, yeah? So basically everything you can charge for. I think the main probably one that gets quite sort of contentious is changes in law, yeah? So often they will say, yeah, if they're particularly in a regulated environment, you're creating a piece of software, they will say, look, if there's a change in law, you will need to make sure that the software complies with that change in law. Well, your response should be, look, we're not the regulated entity, you're the regulated entity. We've got a whole lot of customers in a wide variety of sectors, so, it's your responsibility. If you want us to modify it to comply with future changes law, yeah, we'll do it, but we'll charge you for it. Yeah, you don't want to be, worst position is that basically this is baked in, and then you're basically tied in for ransom. So when there's a change of law, you've got to modify it and you can't charge for it.
What sort of changes in law, normally you can see them coming. They don't just suddenly appear one day. There's lots of regulation. They say that you've got 2 years and it's happening 3 years, 4 years, so you should be able to see most of what's coming along.
Yeah. Although, even if you can see, if you accept that, then you need to build that into your pricing. If you accept an obligation that the software will comply with law, you need to do that sort of future forecasting and horizon scanning and say, okay, we know that's coming in, so there will be further development. We need to charge for that. Yeah. So, as I said, it's an agreement to agree. So agreements to agree aren't enforceable. So as I said, you can't force another party to agree. Forcing, it's often customers will try to force the consultant to actually implement changes. So because there's an agreement to agree, sometimes the change control procedures say, well, there are these specific areas of law, specific areas where, you are forced to implement the change. The usual one is a regulatory change saying, well, you have to do this. You can charge for it, but you still have to do it. Or it could be a security vulnerability. Again, they're saying in that case, you have to do it. So, I think that's okay as long as you recognize it and you have the ability to charge for it. And obviously you've got the technical ability to actually deliver that as well. But you may want to get out for the consultant. So the most common get out is effectively saying, this is just too difficult. Yeah, we can't actually do it. So you can't actually force us to do it. Yeah. Or the other get out is you're not paying us the reasonable amount for us to do it. Yeah. The other sort of tip for change control, I would say, is the rationalization or reinstatement of a new baseline contract. So you've got a contract you sign, And then effectively there's a change control, and 5 years down the track, there's like 20 change controls. One change control modifies a clause, the next change control modifies that clause again. So, basically looking 5 years down the track, you don't know what the contract looks like because there's a whole lot of change controls. Yeah. So it's a good idea that effectively every, I don't know, it depends on how many change control notices are likely to happen. But if there's a lot, maybe every 6 months or a year, then there's a provision where you basically reinstate the contract. Now, if the customer if the client expects you to do it, you should be able to charge for it, so that'll be additional service. But obviously, if you want to try to put that obligation on the client, because then both parties know where they're standing. Because the worst thing is you just don't know what the terms say. Sometimes I've seen change control notice that actually modify a clause which doesn't actually exist because it was like removed in a change control notice earlier. So yeah, a recipe for disaster. So termination. So you want to keep, obviously, as a consultant, you want to keep the termination triggers, i.e. the ability for the customer to terminate, as narrow as possible. So, is it any breach or a material breach? Obviously, a material breach is better for you because you don't want them to terminate for any breach. What about a material breach are capable of remedy? Again, you don't want them to terminate because you remedied it. Also, sometimes customers say, well, this breach is deemed to be a material breach. So what they will say is, for example, sometimes they say, and Lili will touch upon this, is saying, if there's a breach of GDPR, that's deemed to be a breach. So they don't actually have to prove that breach is a material breach at law. So again, you want to avoid deemed material breaches. Insolvency, I think that's something hard to avoid if they say they want to terminate for insolvency. Change of control, this again, you may want to push back on this because often clients say if there's a change of control, we want a right to terminate. Your argument should be, look, we should be in control of our own destiny in the future. We can't have you terminating where, if there's a change of control. We're happy to notify you, but, there's no termination right. Again, like all things, it depends on your negotiating leverage.
Question, John.
Yeah.
You were saying the termination because of insolvency.
Yeah.
What's happening if, because when a big company becomes insolvent, you will have a list of people that will get money first. So I understand that how you will address that in the contract, that you want to be one of the guys that get the money first.
Okay, so I was talking about insolvency of the consultancy, but you're talking about the insolvency of the client. Yeah, unfortunately, it's very difficult to get preferred creditor stage. What you may want to do is have some kind of escrow, payment, that they put the payment before, into some kind of account, or, basically they pay in advance. But, it's very difficult for you to, be a preferred creditor. I've seen sort of really complex consulting engagements and, where it's like a big four as a consultant. Yeah. So they would put in their consulting agreements, we'll move back to them as well as acting against them. They'll have this thing called a financial distress schedule. So effectively that sort of basically if there's sort of if the customer's credit rating changes or bank guarantees change or there's various sort of triggers, then there's certain things that happen, like a notification to the service provider or money into a scrum. But those are for the really complex consulting engagements, yeah. But for the straightforward ones, I think, get as much money up front. do your due diligence. I mean, I think that's pre-contract, yeah. Make sure, you do the financial checks on the customer, but try to get as much up front, yeah. And obviously, if you're invoicing monthly and they're not paying monthly, that's also, an issue, yeah. So termination for convenience. So this is effectively the client terminating when it doesn't have any reason, i.e. just wants to walk away, yeah. So if there is such a right, you want to make sure that that you get recovery of your mobilization costs. So you may have called upon a lot of the consultants, you may have invested a lot. So if they sort of cut the contract short, you want to say, well, you need to pay us for these sort of mobilization costs, the unrecovered investment or the sunk cost, and obviously you want to be paid for work in progress. So you don't want to be in the situation where there's a work in progress, you have an invoice, they terminate for convenience, you say, well, you've still got to pay. So all those need to be built in if you offer the termination for convenience, ideally, as a consultant, you wouldn't want the customer to have a termination for convenience. Exit management, so this is sort of disengagement at the end of the consultancy. What is this? Often customers will ask for exit management services and disengagement. So you need to know what the scope is, what the duration is, and what the fees are. I've seen consultants caught out by this in the sense that they have very onerous exit management disengagement obligations, but they can't charge for it because there's no express ability to charge for it. It's all included in the pricing which they agreed in. So again, something to watch out for. So protections for the consultant. So how can you make this contract better for you? You could have an assumption section saying, these are the assumptions we're basing our scope of services on the pricing. Obviously, if the assumptions don't hold true, you can say, well, we need to adjust the pricing or timetable. So assumptions really important. Force majeure, obviously, that's an important clause to have in those things which are beyond your control. You're not responsible for delivering and so forth. So that's an important clause. Subcontracting, if you are subcontracting, you may want to say, well, we're subcontracting, but we're not actually responsible for the sub. If you can get away with it, that's great, but most customers will sort of see through that. But that's, again, depends on how sophisticated your customers are. And I think, we've touched upon this, the risk of insolvency of the customer. We've talked about, what the options are. You may want to limit audit rights. Often customers ask for audit rights. You want to try to keep that as limited or not offer it. You want to limit step-in. So these are for outsourcing or services agreements. Often customers would insist on step-in rights where they actually step in. You want to try to resist that or limit it. And you obviously want to limit benchmarking. You don't want a situation where they're benchmarking your services or pricing and asking for reductions in price. So those are things you need to think about. And that's me. So before we go to Lili for data protection, any questions?
We have one question inside. William Hooper is asking about protection, price change, and inflation. William, can you turn at least your mic and voice yourself?
Mr. Hopper, how are you?
Hello there, Sam. Up until about 2 years ago, one wasn't too worried about inflation, but all of that's changed. So it was just another idea for protection is, for goodness sake, give ourselves a price escalation clause.
I think that would be, that would be important if you agreed a fixed fee. If you didn't agree a fixed fee, and if you're doing it on a time and materials basis, then you should have a clause saying you can adjust the pricing without linking it to inflation or not. In fixed fees, I agree. If you have a fixed fee, then you would want a specific clause saying, if there's a particular inflation, then you're able to adjust your fixed fee. Does that answer the question?
Yes, it wasn't really a question. It was an observation. Thank you, Sam.
All right.
Thank you. Thank you very much.
Okay.
We can maybe later have a round of Q&A for both of you. I planned it.
Fine. Okay, cool.
Thank you, Sam.
Okay.
Hello, everyone. I'm Lili. I'm a senior associate with Silva, specializing in data protection. Today, I will talk to you about a few things to bear in mind when data protection comes into play when negotiating the contract. To start with, we will set out the definitions for a few important terms so that we can correctly identify the roles of the contracting parties. So, first of all, we know that UK data protection laws, GDPR mainly, impose obligations on both controllers and processors. Controllers are the main decision makers who exercise overall control over the purposes and the means of the processing of personal data. They have the highest level of responsibility under UK GDPR, and they are subject to the most obligations. Generally speaking, the client will be the controller in respect of data processed in the course of the consulting relationship, as they decide the means and the purpose of processing personal data. On the other hand, we have processors. UK data protection laws impose obligations on processors too. They are the entities or the people that handle personal data on behalf of and under the instructions of the controller. So they don't make their own decisions, but they have to process the personal data in accordance with the controller's instructions. They have few responsibilities as compared with controllers, but still need to comply with some rules that apply directly to them, such as, for example, the obligation to put in place technical and organizational measures to protect the personal data. Depending on the context of the engagement, consultants will sometimes be a processor and sometimes be a controller. The important thing is to understand, in the context of this specific engagement, who makes the decisions in respect of personal data, who is following instructions. We might have both of the parties as controllers, and we'll talk about this later on. We might have a controller and a processor. Article 28 of the UK GDPR contains specific rules that apply to controllers in respect of appointment of data processors. This article requires that when a controller engages a processor to process personal data on its behalf, it must put in place a written contract with the processor. This contract must contain certain mandatory provisions that are set out in law. It is also important, as Sam said before, to carry out due diligence in advance of the engagement to make sure that there are adequate measures in place to protect the personal data. When contracting with a third party that is based outside the UK, we have additional requirements that apply, but we'll talk about this later on. So what happens when both parties are controllers? So we have two separate scenarios here. One of them is they're joint controllers, and the other one is independent controllers. They are joint controllers when they are jointly determining the purposes and means of processing the same personal data. They share the purpose. Whereas if they have different purposes, so each party is processing the data for a different purpose and they have different means of processing the data, then they are independent controllers. Of course, if you have any questions as we go, just let me know. So it's important to understand a few key terms. First of all, what is personal data? Data protection laws apply when you're processing personal data, which is any information that allows you to identify an individual. It includes, amongst, of course, other things, names, email addresses, contact details, date of birth, photographs, video footage, bank and payroll details. In practice, some places that you might find personal data in includes correspondence, for example, emails when there is an email address with someone's name, DBS checks, CVs, visa applications, forms, surveys, for example, relating to diversity, etc. This personal data might relate to individuals such as applicants, employees, suppliers, even individual consultants. That is the individuals that the personal data relates to, and they are called data subjects. Under UK data protection laws, we also have the term of processing. Processing is defined very broadly to include almost anything that you can do with personal data. It includes collecting, recording, storing, any way that you can use personal data, even deleting it and sharing it is considered as processing. It's reasonable to assume that if you hold or have even access to personal data, you are indeed processing it. There are certain types of data known as special categories of personal data, or under the previous regime, they were called sensitive data, which require a higher level of protection just because of this sensitivity. These types of data can only be collected and used where a specific condition applies, and this condition has to be set out in law. The UK GDPR defines special category data as personal data revealing racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, genetic data, biometric data were used for identification purposes, data concerning health, sex life, and sexual orientation. It does not include personal data about criminal allegations, proceedings, or convictions, But still, we have special rules applying to this data because, again, it's quite sensitive. And then we need to think about who are the data subjects, because this might mean that we have a higher risk. For example, if you have children or any other type of vulnerable individuals like elderly people that are concerned, we might need to have higher controls in place to make sure that they are adequately protected. Then again, we need to consider what are the data flows, and if we're sharing data, the parties are sharing data with each other, is the one-way or a two-way thing? So is it the data is flowing just from the client to the consultant, or the consultant is also processing this data in some way and then returning it to the client?
I have one question from the audience. How do you consider GDPR when you're doing consultation with a global company? As will you be working on several PCs across the globe, and who will be controlling? Who will be in control of, and who will be the processor? I'm just going to ask Srikath to join us again and verbalize the question.
Thank you. I'm sorry for the disturbance, actually. Basically, this is when you're doing consultations on the infrastructure specifically, because for a global company, you'll be working on global data centers, right? So you'll be working on different locations across the globe. So how do you consider GDP? And in this case, who will be the controller and who will be the processor?
Yes, thank you for your question. So the roles of controller and processor are not changing in this situation. If the EU or UK GDPR, because at this point they're still quite similar, this may change in the future according to what the government is thinking at the moment. The control, if the UK GDPR is applicable, we have the controller who is deciding how the data will be processed and why. And then we might have another controller or a processor, depending on the context of the relationship. Then we have other rules that come into play when we have an international data transfer. So if the data is, as you said, hosted, for example, in a data center in India, this might qualify as a restricted transfer, and we'll touch upon this thing later on in the presentation because we need to have additional things in the contract. I know that this doesn't fully answer the question, but I will cover it later on and then we can discuss again. Great. And then, of course, we need to think about if the consultant intends to engage other processors, other sub-processors, other people that are engaged in processing personal data, then we need to have obligations flowing down to them too. And other things to consider are if we have issues revealed through pre-contract due diligence or a DPIA or data protection impact assessment that the controller has to carry out before the processing. And then this is for cases of high-risk processing. For example, as we said before, children data, health data of children. That will be a very high-risk processing, as you can imagine. So then we might need higher controls. So first of all, I said before that we have Article 28 of the UK GDPR about control and processor relationship and the contract and what the law itself requires the contract to have. We have a few provisions that unfortunately, or maybe fortunately, are not negotiable. So we have to have these things in place, and it's in contrast with what some said before about other provisions, like, for example, we don't want to be fully liable for our subcontractors. In this case, GDPR, if you are indeed a processor, asks you to put these provisions in the contract. First of all, the contract has to contain details of the processing, including subject matter, duration, nature, purpose, types of personal data, categories of individuals, and the obligations and rights of the controller. And then we have a whole host of provisions about the consultant's obligations when the consultant, again, is a processor. So this means processing personal data only on the documented instructions from the controller, unless the consultant is required to do so by domestic law, in which case sometimes we need to notify the controller. Impose confidentiality obligations on persons authorized to process personal data. That sometimes can be, for example, in an employment contract or in a consultancy contract. Take all measures required by Article 32 of the UK GDPR, which speaks about the security of the processing, and that could include pseudonymization of data, encryption, or multi-factor authentication, for example. Only engage sub-processors with the prior specific or general written authorization of the controller. And then when you're engaging with sub-processors, then you need to flow down equivalent obligations. So again, it has to be a contract that includes at least the same level of protection that you afford to the data through your original contract. Again, the processor has to remain fully liable to the controller for the sub-processors. So unfortunately, this is a GDPR obligation. We can just really exclude ourselves from that. The processor must also assist the controller with a few obligations that they have under the GDPR, including security of processing, data subject requests for exercising their rights, data breach notifications, the data protection impact assessment, as we said before, and prior consultation with supervisory authorities when there is very high risk processing. The processor must also delete or return personal data. This is at the choice of the controller, unless domestic law requires storage. For example, some laws require that you keep data for a specific period of time in case there are claims or anything else. And then the processor should make available to the controller all information necessary to demonstrate compliance and allow for and contribute to audits and inspections. It's quite stringent, but there are provisions that we can make this look, for example, less stringent than it is. Let's say that you are allowed to audit me, but only once per year and in specific cases, and you have to give me advance notice, and you're not allowed to disturb my normal course of business, etc. We also have the provision that the processor must immediately inform the controller if it believes an instruction infringes any UK data protection provisions. And of course, this is normal. You wouldn't want to be in breach of data protection laws. So when reviewing a DPA, a data processing agreement, or data processing addendum, if it's an addendum in another agreement, we suggest looking for a few key provisions. First of all, we have the scope and the jurisdiction. We need to understand what personal data is in scope and which jurisdictions they cover. This is because sometimes data protection laws have an extraterritorial scope, which means that they apply when there is a sufficient link or connection. For example, when there is monitoring of data subjects. Just as an example to illustrate that better, we've been working recently with someone, a contract entered into by the client entity, which was established in Australia. So not UK, not EU. Theoretically, GDPR wouldn't apply here. The individuals to whom the personal data related to were from Australia, New Zealand, Singapore. Again, no connection with the EU. However, the processor was a Spanish entity. So the EU GDPR applies here due to the establishment of the processor in the EU, regardless of the location of the controller and regardless of the location of the data subjects. Then we have definitions. Definitions, as we said before, can be important. For example, process or processing is a very broad term. Under applicable law, it can include, without limitation, collection, storage, even accessing, even deleting it. It's also important to check the definition.
People are saying that they have problem to hear you. Can people in the audience hear Lili properly? Please.
Where's the microphone? Is it?
That's behind you.
Oh.
Yes. They can hear you.
I can hear
okay. I just have an old yeah.
Should I be moving closer to?
No, that's fine. They can hear me too. So.
Okay. Okay. I was saying about the definition of data protection laws itself. You should always check it to ensure that the scope is correct. It's very important to check that the DPA contains a schedule or a clause that sets out the information required under UK GDPR, especially when there is a processor involved. This includes data subject types, types of personal data, the nature, the purpose of the processing, duration, subject matter, and obligations and rights of the controller. These should actually reflect the actual circumstances and context of the engagement, so it's important to ensure that the parties' understanding is aligned here. Thirdly, we have security incidents and data breaches. Another crucial provision is how broadly you define security incident or any similar term like a personal data breach as used in the DPA. This, for example, you should check whether the contract requires you to inform the client about not only actual or confirmed incidents, but also about any suspected ones. This is because the clients may want mitigation and remediation to begin immediately when there is a suspected incident, as opposed to waiting possibly even weeks for the consultant to complete the forensic and the due diligence into whether a breach actually occurred. Be mindful of what the contract sets out as a notification period for any security breaches. Usually the processor is obligated to give the customer prompt notice of any actual or alleged security incident, as the controller has to notify the regulatory authority and potentially even the affected data subject within a prescribed period of time, which is 72 hours upon becoming aware of the breach.
I have one question. What happens if the customer or the client doesn't request the DPA? And the question is coming from Charlie.
If they don't request it?
Yes.
So, first of all, we need to establish, is personal data processing, we said for this personal data, is any information that can identify an individual. If there is personal data involved, we need to think about the roles of the parties. So do we have a controller and another controller, or do we have a controller and a processor? If we have a processor, in this case, yes, we do need to have a DPA. It doesn't have to be an addendum. It can be within the main front end of the contract. But you do need to have the Article 28 provisions, as we said before. If it's a controller-to-controller relationship, I'll cover this later on.
Okay, thank you.
I guess maybe question is, well, I think you've answered this question is, what about if the client wasn't astute enough and haven't asked
they don't want, there is personal data involved, but they don't want a DPA. That would be interesting. Depends on how sophisticated they are. If, for example, we have a bank as a client, they most of the times have their own DPAs and they don't even accept any changes in that and negotiations. But in any case, because it's an obligation from law, if you are a processor, you need to add a DPA. Don't ask ChatGPT to create a DPA, but just something basic in place that even includes the bare minimum of GDPR should be there.
So I think the key takeaway is that, just because the customer doesn't ask for your client, you still need to have one in place. So you can't just say, they didn't ask for it, so we can't worry. We don't need to worry.
I guess are you still liable under GDPR if you're processing personal data or sensitive data anyway, irrelevant to whether you've got a DPA in place?
Yeah, and you would be in breach for not having a DPA in place in addition.
So basically you say to them, if they don't give you a DPA, you're not processing any confidential data.
Or any personal data.
Any personal data,
Chris, Charlie, if you want to follow up, just write a note. We can follow up also on the Q&A session.
Great. So then we move on to indemnity and liability. The position we are seeing in the market following GDPR is quite different from what we saw under the previous regime, which was the Data Protection Act 1998. It's less usual now to see a blanket statement of unlimited liability for breach of the data protection provisions of the contract, in the same way that you might still generally see for breaches of confidentiality. What is seen generally breaks down into the following. First of all, a financial cap on liability, which is different from and separate to the general cap for contractual damages. The amount will depend on the nature of the data, the type of the processing, and the bargaining power, of course, of the parties. And then we also see an exclusion of indirect losses and a list of specific losses which are deemed to be direct and therefore recoverable. This may include, for example, internal additional costs, remediation efforts with data subjects, cost incurred generally in dealing with the fallout from data breaches, etc. So what do you need to be mindful of when negotiating data protection, indemnity, and liability? Step one, identify any actual risks from data processing. And second, think about what the consequences of the risk are generally, and possible costs and losses. So this could be statutory compensation claims from data subjects, complaints from individuals, maybe any monetary penalties from regulators, reputational damage and adverse publicity, loss, misuse, and corruption of personal data. So anything that can harm them and they want it to be covered, they are trying to put there. But yeah, don't agree generally to unlimited liability, probably the very wise option. And now we are coming to the international data transfers, and hopefully I will answer the question from before. When contracting with a third party, either a controller or a processor that is based outside the UK, we need to have additional requirements. International data transfers are permitted under the UK data protection laws only where there are adequacy regulations in place in relation to the location where the data will be transferred. This means that the UK government has decided that the relevant location offers essentially equivalent levels of data protection, equivalent to that within the UK. Current UK adequacy regulations are in place for all countries within the European Economic Area, as well as for a few other countries such as New Zealand, Switzerland, Japan, and others. If there is no adequacy decision in place, for example, say India or the US, then personal data can still be transferred where there are standard contractual clauses in place. These are standard sets of contractual terms and conditions that the sender and the receiver of personal data both sign up to. These standard sets are issued by the regulator. You can just put whatever you want. You have to use the exact same form in your contract. These obligations help protect the personal data when it leaves the UK. And where these clauses are used, there is a requirement for organizations to undertake and document additional due diligence known as a transfer risk assessment. This is to decide whether the standard contractual clauses can provide protection for personal data, which is again essentially equivalent to the level of the UK. If they cannot, then it might be necessary to put in place supplementary measures to protect the personal data, for example, encryption. So just a quick recap, what is a joint controller? Where two or more controllers jointly determine the purposes and means of the processing, they will be joint controllers. Joint controllers decide the purposes and means of the processing together. They have the same or shared purposes. And controllers will not be joint controllers if they are processing the same data for different purposes. In this case, they will be independent controllers. What are the responsibilities of joint controllers? You need to decide with your fellow joint controllers who will carry out and which control obligations under the UK GDPR. However, regardless of those arrangements, each controller still remains responsible for complying with all obligations of controllers under the UK GDPR. It's important to remember that joint controllers must have an arrangement between them that determines their respective responsibilities for compliance with GDPR. The main points of this arrangement should be made available to the data subjects, to the individuals. In particular, you must decide and be transparent about how you will comply with individual rights and with the transparency obligation. That is, how you will provide the information, the privacy notices to the individuals. And the privacy notices have to say specific things that are in Article 13 and 14 of the GDPR. There are very specific things like the purpose of the processing, the lawful basis you rely on, etc. You may choose to specify a central point of contact for individuals. However, individuals, again, must remain able to exercise their rights against each controller. Most of the times, this arrangement and the assistance and cooperation that each party will offer to each other is documented in a contract. This is also in line with the ICO Data Sharing Code of Practice, about which we'll speak shortly. So it's not a requirement under GDPR to have a contract in the same way that we have when we have a controller and a processor, but in the UK, best practice and what the ICO is the regulator, Information Commissioner's Office, is expecting is to have a contract in place. This is also for contractual certainty for the parties, so it's ideal. So again, we have here independent controllers. We have no prescriptive clauses set down by GDPR, so no minimum content there. It's up to the parties to decide how they want to allocate obligations between them. Remember that it shouldn't be that one controller is instructing the other party to process personal data on their instructions, because then you would have controller to processor, which is under Article 28 specific provisions. A useful guidance for contract is, as I said before, the ICO data sharing code of practice, which focuses on sharing of personal data between controllers. So the code suggests the contractual clauses should address which organizations are involved, what is the purpose, and what is the legal basis of data sharing. When I say the legal basis, I mean, for example, consent or legitimate interest or legal obligations. So what am I relying on in order to process personal data? The types of data shared, and these could include sensitive information, as we said before, the procedure for responding to data subject requests, and any other governance issues such as security, data breaches, how to collaborate when there is a data incident, etc. So now it's question time.
Thank you very much. Yes. Any question in the room? I'm checking a second online. But do we have any question in the room?
So is in GDPR, we used to have the concept of safe harbors, wasn't it? Which is where you had a data agreement, but that was a long time ago. Is that now superseded by?
Yeah, so that was ages ago.
It was a while ago. It popped in my head, and it kind of disappeared. I don't know what happened to it.
So that was something equivalent to the adequacy decision that I said before for transfers of data to the US. That was invalidated because it was considered that it's not actually providing this essential protection to personal data. And then we had the privacy shield, which was also invalidated. So now they're thinking about the successor of that.
So we don't have anything right now then?
No, not yet. So we need to have these contractual clauses that we said before for transfers to the US.
Little question. In the management literature and dialogue, failure is the route to success. And in consultancy, that often you end up with a client and a problem which is quite uncertain. The risks are quite high. And as I was watching your slides, I recognized that I'm often in that situation because I'm an innovation consultant.
Yeah.
And I the more I watched your slides, the more worried I became.
Yeah.
And I'm now counting my lucky stars because I've been really lucky because they're pursued me, which must be a bit of a miracle. Have you got any thoughts on that kind of conundrum? But as consultants, you don't always have a client who knows what they want.
Yeah.
They don't always tell you either. Enough for you to really manage risk down to sensible levels, and sometimes they don't tell you deliberately. Yeah. Any thoughts?
Well, I guess the way to manage the risk is not having any outcomes. So your contract will say it's on you're basically paying for my time. You don't expressly say you're not going to guarantee any outcomes, or you just say, look, my hourly rate is blue, the services I provide is generic, whatever your generic IT consulting or whatever, and that's it.
Is that what we would call a time and material services for assistance contract?
Yeah, but you just need to make sure the scope of work is generic, basically in a way that it just, there's no way you can be caught out on, guaranteeing any kind of outcome or any deliverable and stuff. Yeah.
What happens if you want to go fix? Fixed price.
Yeah.
Right. Instead of by time and material.
Yeah. Well, the thing with the fixed price is often clients will want fixed price, but they'll also want an outcome. Yeah. They won't just say, fixed fee for what? They will want, you will deliver this piece of software or this report for a fixed fee. So that's where you will have an outcome. Yeah.
We have Charlie. Charlie, do you want to come and ask the question?
So, I was just wondering, guys, I mean, in terms of, I missed the start, unfortunately, because I was driving. Did you cover IR35 concerns?
No.
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 Okay, so...
You like? No. I mean, that's really an employment law issue, not an employment lawyer. So, yeah.
No, but I think certainly some of the clients I come up against want contracts that kind of give them assurance really about that, because obviously the IR35 legislation really lands on the client for small contracts.
Yeah. I mean that's really for an individual. Yeah, this is not as I said in my start, which you missed. This is not for individual consultants. So this session is focused on consulting firms and SMEs, as the IR35 is only relevant for individual consultants.
Well, yeah, but I guess there's a grey area, isn't there? If you're a small consultancy firm, the contract is with the limited company, and so that kind of covers. But,
no, well, I mean, if the limited company is only one person, then yeah, you get an issue. But I'm talking about SMEs where you've got 5, 6, 10, 15 consultants. Yeah.
Okay, and then the other.
No, but it's a profit. It's a prop. Yeah, I mean, yeah. What I'm talking about is a company, an SME, where it's got employees who are the consultants. Yeah. As opposed to a whole lot of individual consultants.
Yeah, sometimes
who got their
you have a company which does employees and also supplements them with associates.
Yeah.
And then the associates then the contracts with the associates limited companies. Then you have to put all sorts of stuff in to make it look like it's not IR35.
Yeah, I mean that's very interesting. How does it work? When is it start? When is it stop being affected by the IR35 and when it start being under this? So
I mean that's I'm not as I said, that's a tax employment area, which is not my area. Yeah.
Right.
Okay, and then the other quick question I had was, and it's really, I suppose, probably a bit cheeky, but in terms of are there any easy places to go to get some draft templates and stuff for some of the content that's been covered this evening?
Well, no, I mean, you'll just need to find. I mean, as a law firm, we can't really recommend any service provider to do this. Yeah,
right, but you have like a vanilla one, and then it's like a software. You have the free one, you have the upgrade one, and you have the one.
No, we don't have any free ones. Sorry.
No.
I didn't think so. I thought I'd ask the question anyway, just to. I mean,
one of the
online. I just wondered if anybody recommends one. That was what I was thinking. So,
one of the comments that Sam was saying before is that he asked for templates to ChatGPT, and unfortunately he replied that he doesn't legal advice, but maybe does.
Well, so actually that just proves how accurate ChatGPT is, really. Okay, thanks very much. Thank you, guys. Thanks very much.
Okay. So an important factor is if you actually go through a solicitor, then they have liability cover if something happens with the contract anyway, don't they?
Yeah.
And if you get it from ChatGPT,
It's a quick one. Sam, you triggered a thought in my head, which is, do you have any thoughts on what the kind of gold standard would be for a SME IT consultancy or SME tech consultancy? Getting legal support for these kind of things.
Yeah.
What kind of works and what doesn't work? Because as an innovation consultant in AI, I've got time to do all this.
Yeah.
It'd be great to have some sort of relationship with a legal entity that helps me on this.
Yeah.
What works, what doesn't work? Would your advice be?
Well, I mean, I think you probably need a contract. What I would say drafted by a firm of solicitors, a template contract, and then, hopefully you won't need lawyers going forward in terms of, hopefully the modifications will be, minor, but obviously if there are material changes, then you will need to get, legal advice with a change in the IP position or the liability position and stuff. Yeah.
Is it a good idea to have one such relationship with?
I mean, it depends. It depends on the firm. It's up. There's large international firms like us which do everything. Then there's smaller firms that only do certain things. And what I would recommend is for this kind of stuff, don't go to your high street lawyer who does conveyancing. Yeah, you want to go to a firm which is reputable and does this day in day out. So yeah.
Thank you. Thanks.
I don't see any text online, so I'm just going to proceed with the end of the meeting. So thank you very much, everybody, for joining us.
Thank you.
I've run home now and look at my contracts.
Sorry? That's it?
Run home now and look at my contracts. There again, 5 years.
Yeah.